Plugged in a stick which had about 15 illegally downloaded episodes of Game of Thrones. So that would be a different cordial altogether. Yeah.
Was that off bigger upload?
Yes, it was. Okay, is it the top normal one or the bottom normal one? This is the PowerPoint one here. And she's ranking.
Right, so just the counters.
You can use the mouse from here. Now, I'm not sure what happens if you click this button each time. It'll change the slide maybe. Click it once just to check. Nothing.
No.
Nothing.
Right.
No. Other button? No. Okay, you do have to
All right,
use
I'll
it.
know.
Oh wait, it did work. It did work. That's good. That's good. Stop what you're doing. Okay. Let's try that one again, shall we? That's the first slide? No?
Nope.
That's the first slide. F5. And when you want to click a slide, just click this one.
Reorganise my.
Well, no, I just use
Yeah.
Word on my work computer, so yeah. But it takes a while to change the slides as well.
Okay.
Yeah. One click, one slide forward. There you go.
Alright, morena tātou katoa, ngā mihi nui, ngā mihi mahana kia koutou, ngā tangata whenua, ki ngā manuhiri, kua tai mai nei, mō tēnei kaupapa nui, tēnā koutou katoa. Ko Kylie Quince tōku ingo, he uri o Ngāpuhi me Ngāti Porou, nō reira ngau mai mihi mai. Morning everyone, my name's Kylie Quince, as Chris has said, and my PowerPoint has also done some funny thing, but anyway, we'll roll with that. So warm greetings to you. As I've said, my name is Kylie. I'm from South Hokianga on my mother's side, so that's Te Roroa, Ngāpuhi, Ngāti Korokoro. My father's side, East Coast, so Tiki Tiki, so Ngāti Porou, two of the premier dope growing regions of New Zealand.
So say North Islanders.
So in my professional life, as Chris has mentioned, I'm the Associate Dean Māori, the Tumuaki Māori at the Faculty of Law at the University of Auckland, where I've taught since 1998. And before that, I practiced criminal and family law for a couple of years. So my main areas of teaching and research are criminal law generally, but particularly criminal law and youth justice as they affect Māori, rangatahi Māori. So that's my bag. Now, a lot of what I want to say overlaps with what Fiona's already said, so I'll confirm some of the information she said, but I really want to focus on talking about the law as it relates to cannabis prohibition and why it's not working. So particularly a legal perspective, but in terms of the New Zealand impact, of course, I want to talk about the impact of prohibition on Māori people particularly. So, and come back to the question that was asked behind me about not just the formal legal consequences, but the collateral consequences of prohibition, particularly conviction, criminalisation, conviction and punishment. So collateral consequences in relation to immigration, employment, so ongoing stigmatisation and marginalisation of people with convictions. And as Fiona's mentioned briefly, that has a particular differential impact in Aotearoa in relation to Māori people generally, but particularly rangatahi Māori. So I want to talk about that briefly too. So why is law reform, now am I going to get this right?
Wrong button,
Going
the other
the wrong
one,
way?
that one, and you only click it once.
All right. Phew. Right. When is law reform necessary? Now, basic sort of law 101, when lawyers talk about or think about changing the law or making a new law, this is the sort of evidence, this is our process as social scientists, if you like, is to think about objectives, what is it that you were trying to achieve, and think about those other issues, such as whether or not there's a public mandate to do what you want to do or to leave something as it is. So a loss of mandate will of course be relevant. Matters of efficiency, which again, so economic matters, which Fiona's already mentioned. If something is economically inefficient, again, that's a good reason to change the law. And lastly, and the thing that I'll talk about the most is, of course, discriminatory application of the law. So if there's a differential impact of a law on particular populations, on groups of particular people, then again, that's another reason perhaps that we might want to change what we do. Interesting, I was thinking about one of the, you know, when Fiona's talking about looking at matters other than pure evidence, yeah, and this idea of populism, of course, so I just found that graphic of a poll result from Campbell Live as a time to decriminalise marijuana for personal use. So overwhelming support. But of course, I also thought it was quite interesting over the last couple of months. Now he's moved on to something else, which I can't remember what it is, but Campbell, of course, for a couple of months, Campbell Live for a couple of months was the nightly update on synthetic cannabinoids. Every single night. It was quite bizarre. So really, you've got this momentum of populist attitude around legal highs, or now illegal highs, but synthetic cannabinoids generally, a sort of project of the day. So those are some of the reasons that, that from a legal perspective, we might say that law reform is necessary. I am going to go quite quickly because there's nothing that will make a Māori speak quickly, more quickly, than being the last person between you and a kai. So, being the last bastion between me and morning tea, I'll whip through the stuff, and it's also quite, you also feel a bit silly preaching to the conversion. So, anyway, evidence that we have that the cannabis laws, as we have them, are not working. Again, Fiona's mentioned this, the fact that our Misuse of Drugs Act is nearly 40 years old. There are things you can say about something being 40 years old generally. And again, I was reminded of, I turned 42 last week, and I was reminded of, I had a police prosecutor come into my criminal law class 2 weeks ago, and he was all of about 13. And he was explaining, I asked him to come to talk to the class about, processes of discretion. You know, when would we choose to, particularly talking about the public interest test, you know, when would you choose to prosecute and when would you choose to take an alternative means or use an alternative method following an apprehension. And so he gave my class a couple of different scenarios, real cases that he dealt with in the last couple of months. And one of them, he said, so involved a very minor assault between parties that knew each other, who both had been drinking, so they were in a pre-existing relationship, and he wanted to talk about the fact whether or not it was in the public interest to prosecute these people. And anyway, the students were discussing this, and then he said, something you might consider is the fact that neither of these people had prior convictions, and the male assaulter, he was really quite old, 44. So he nearly got a roundhouse to the face. So, but the fact that a statute has been pretty much untouched for 40 years from a criminal perspective or even from a general legal perspective, that's pretty unusual. That is ancient in legal terms. As we know, generally a public shift in attitude towards and use of cannabis. Again, Fiona has covered that. There isn't this great fear, I suppose, and particularly, so both the attitude towards and the significant use of cannabis in a social context, at least in New Zealand. Enforcement costs tens of millions of dollars. And again, in terms of the spectrum of offences that you're dealing with, of course, that's heavily weighted towards possessory offences, which is just not a very good use of public money. But again, as I said, the thing that I want to talk about most is the actual racism in policing, charging and convicting for cannabis-related offences, and particularly possessory-related offences. Now this is a global issue, as Fiona's mentioned, in terms of the differential impact or discriminatory enforcement of drug laws, and particularly possessory drug laws, impact negatively upon and disproportionately upon black people and minority people in the UK and also in the United States. So this is just our local version of that. But the point one of the points I want to make is that this isn't anything unusual, of course, for Māori. This is part of our ongoing long-term relationship with the law per se. So this isn't special. This is a still shot in the larger film of Māori relationships with the law, really, and with the police too. So with law enforcement agencies. So I want to talk a little bit about that quickly. It's always very difficult to nail claims of systemic racism and claims of improper use of discretion. That's the nature of discretion, right? It's really difficult. Police officers don't take notes that they're pulling over someone for that, offence of driving while brown. They don't, and they're not going to self-report that kind of behaviour. So it is very difficult, but notwithstanding that it is difficult to question processes of discretion, how they work and patterns, we can do this from the other end, which is you can look at the hard data in terms of apprehensions, convictions and punishment and work backwards from that. So you can at least say that the data does clearly show that Māori people are arrested, more likely to be arrested, more likely to be convicted and more likely to be punished than non-Māori people in New Zealand. And as I've said, that's not just in relation to cannabis, but in relation to criminal offending and apprehensions generally. I would like to talk more about, but I don't have time today within the brief of today to talk about why that happens. Why do we have this discriminatory or differential impact of cannabis-related or policing of cannabis laws against Māori people? Very briefly, I'd say that is really about it's not just about race or ethnic or cultural identity, of course. That's about the intersectionality or the intersection of our socioeconomic positioning, of our sometimes gender identity, and particularly our class, geography and age. All of those factors compound or intersect with one another so that we are an over-policed population. Young people are over-policed, Māori people are over-policed, poor people are over-policed. None of those populations have the privacy that I have, not as a Māori person, but as a middle class person. As a middle class person, my class and socioeconomic positioning causes my race to be read and responded to in a certain way. I'm not going to be called over by the police, and I'm not going to be, no one's going to come knocking on my door and asking if I'm smoking after hours, because that's the privilege of my class. That's the privilege to some extent of my gender. So that suppresses the negative impact of my ethnic or cultural identity. So it's a complicated idea to unpack why discretion works or doesn't work in certain ways. What we can say, again, in a bigger sense, rather than just looking at policing of marijuana or cannabis-related laws, is that we do have self-reported systemic racism in New Zealand from police. It's a rather old study now. I'd like to see this updated. But Te Puni Kōkiri and the New Zealand Police did this mirror study in 1998, police attitudes towards Māori, Māori attitudes towards police. So there were 800, I think, police officers questioned about their practices in relation to Māori people, and similarly a very broad demographic of Māori people were questioned about their relationship with the police. Now, they were mutually reinforcing negative stereotypes of one another. I thought the really interesting thing about the Māori aspect of that survey was that irrespective of class, irrespective of income, irrespective of gender or age, Māori have negative attitudes towards the police. And so that's not just about your personal experience as being a young person or someone who is actually over-policed. And of course that comes down to our preference for identifying not only collectively, so you think about the experience of young people in your whānau, in your hapu, but also the fact we identify intergenerationally, that you think about not just young people that are related to you now or people who've been subject to police harassment now, but of course historical relationships. And of course we saw that in the Operation 8 Uruwera issue, the different idea of our collective conscious as Māori people compared to this idea that you've got this one-off incident, that we don't think like that. We don't view the law like that. We don't think of the police like that. So we have this mutually reinforcing behaviour about the police. So of course that means that when people are stopped, they may not be able to, whether it's by reason of their age, their gender or their income, their education, we're not able to navigate our way out of legal trouble in the way that other people are. You're not able to or you don't want to speak politely to the police, or that's problematic. You have and of course we see the same behaviours in education in particular, with the old Kiwi suspension, with Māori kids speaking back to teachers at school. So this is only this is a microcosm of a lot of wider relationships between Māori and the Crown, all aspects of the Crown. Why should we be concerned about this in a legal sense, this pattern of charging and convictions, over criminalisation and over surveillance of Māori? As a lawyer, I would say these things, that pattern challenges the rule of law. That's quite a broad philosophical point, but specifically breaches domestic and international civil and human rights laws. Breaches in our domestic terms, it breaches Article 3 of the Treaty of Waitangi. So Article 3 is our equality provision, that in exchange for Articles 1 and 2, the last part of the bargain is this promise of equal citizenship for Māori. So the promise of equal citizenship. And non-Māori, yes, yeah, absolutely. So that we are to be, and so it's that equality in terms of being equal citizens before the law. And so this is, patterns that of over-criminalisation and discrimination in policing, of course, breach that. Again, why does that matter? It matters because it reinforces, again, something Fiona mentioned briefly, social exclusion and marginalisation of Māori, but of all people that potentially have a cannabis-related conviction. I'll race through the rule of law. The rule of law is basically this idea of that the law should be fair, just, and promote equality of citizenship. So it should be applied against citizens without fear or favour. And that's really basic. I mean, that shouldn't be controversial. One particular principle that lawyers hold dear in relation to the rule of law is the idea of fair warning. Fair warning means that any citizen should be able to go to the library, look up online, find out the contents of the law, so the parameters of it. Is this thing legal or not? Is this thing lawful or unlawful? If I do this, if I behave in this way, am I breaching the law? That's the first aspect of fair warning, the content of the law. Then there is the application of the law. So I look that up and I can see that that's against the law, Misuse of Drugs Act, Section 7 or whatever it is. Are the police going to, actually, if I'm apprehended, are they going to charge me? So as we know, over the past couple of decades in New Zealand, because the Misuse of Drugs Act is so old, we have moved to effective de facto decriminalisation. From you might